case number 21CR070, State of Ohio versus Lacey K. Hildebrand. And Ms. Hildebrand, yeah, I'm looking at your screen says Kaylee Hildebrand. Is that your middle name?
Haley's my daughter.
Oh, your daughter. Okay, all right. So you're appearing on the screen mark Lacey or Kaylee Hildebrand, but that is you, Lacey K. Okay. All right. Also, this hearing is being conducted by Zoom due to COVID-19 issues. Ms. Hildebrand's attorney, Daniel Wiz, appearing from her office, and Assistant Prosecutor King is appearing from his office. Now, Ms. Witt, you and your client both have agreed to waive her appearance and then submit or conduct this plea by Zoom rather than in person.
We do, Your Honor.
And you're agreeing with that, Ms. Hildebrand?
Yes, sir.
All right, thank you. All right, this matter was set for a plea, and I have received a plea of guilty form, Ms. Hildebrand. Once I'm going to hold up the camera, show you there that has your name and your phone or your case number on it. It says plea of guilty form to count 1, I believe. You see that?
Yes, sir.
All right. And then on page 3, there are some signature lines toward the bottom. There's a sentence that reads, I enter this plea voluntarily. Immediately below that, it looks like there's a signature of Lacey Hildebrand. Is that your signature there that's next to my finger?
Yes, sir.
When did you sign this agreement, Ms. Hildebrand?
About 20 minutes ago.
Okay. And at Ms. Witt's office?
Yes, sir.
All right. And did she go over with you and explain everything to you?
Yes.
You understood that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And have you had enough time to fully consider this matter before making this decision?
Yes, sir. I was under the assumption you were going to have a PSI for sentencing.
That's what it looks like, yeah.
Okay. Yes, sir.
I would order one if you plead guilty, yes. All right. Now, do you feel you've been rushed or pushed in any way in making this decision?
No, sir.
Are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
Right now, on page 1, it states you're going to withdraw your not guilty plea and plead guilty to the charge of burglary under 2911.12A2 of the Ohio Revised Code of second-degree felony. Further states that you understand that the maximum prison term for that is 8 years. The minimum that can be imposed by the judge would be 2, and there's a fine of up to $15,000. And there's also a presumption that there should be a prison term imposed, although it's not mandatory. Do you understand that?
Yes, sir.
All right, now under the law, Ms. Hildebrand, this degree of felony has a potential indefinite sentence. So what that means is that the sentence that is imposed by the judge is a minimum. So I can impose anything between 2 and 8 years. Then the Department of Rehabilitation and Corrections then has the authority under the law, if they choose to use it, to extend the sentence to up to 50% of whatever term was imposed by the judge. So, for example, if it was a minimum sentence of 2 years, then the corrections department could increase that to up to 3 years, 1/2 up to. If it were 8 years, they could increase it by up to 4 years, which would mean 12 years would be potential sentence. So it would be a sentence between 8 and 12. You understand that?
Yes, sir. So does it mean that I have a mandatory 2 years?
No, it's not a mandatory sentence.
Okay.
And it's presumed a prison term should be imposed, but it's not mandatory. And if you get whatever sentence I give you, it's not mandatory, so it would be subject to judicial release, if the court decided to grant it, it was asked. But it's not a mandatory sentence.
Okay, thank you.
All right. Now, other than this charge, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
just as pertaining to this case.
Yeah, okay, that's just pretrial supervision, okay.
Yeah.
Now, under the law, if you are sentenced to prison, and if you serve the complete prison term set by the court along with any additional time that the Department of Corrections decides should be served, upon completion of the sentence, it is mandatory that you be under post-release control supervision. So that part is mandatory. That's only if you serve the entire prison term. And if you do, then you'll be under 3 years of supervision by a parole officer on a term set by the adult parole authority, because they're the ones that do that, not the court. And if they decide, while you're under that supervision for 3 years, during that 3-year period, that you have failed to comply, they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you violate a new felony, or committing a new felony, I should say, during that period of time that you're under supervision, then an additional whatever sentence could be imposed for that new felony conviction. The judge in that case could also sentence you for committing that violation while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
Right now, under the law, I'm not required to sentence you to prison. There's a presumption I should, but it's not required. So, it is possible that instead of sending you to prison, you could be put under under community control for a period of up to 5 years under the terms set by the court. And then you would be supervised by the probation department under those terms. Now, if during that period of time the probation department felt that you had failed to comply, they would have to file a written notice of that with the court, serve a copy on you, and we would have a hearing. If the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to a term of 8 years and fine you $15,000. Do you understand that?
Yes, sir.
Right now, the charge in count 1 alleges that on or about April 3, 2021 in Highland County, Ohio, you did by force, stealth, or deception knowingly trespass in an occupied structure or in a separately secured or separately occupied portion of an occupied structure that is the permanent or temporary habitation of Jeff Burnett and Amy St. Clair, when Jeff Burnett or Amy St. Clair or any person other than an accomplice of the offender was present or likely to be present, with the purpose to commit in the habitation a criminal offense. And that's in violation of section 2911.12A2 of the Ohio Revised Code, the charge of burglary. Now, Ms. Helgebrand, do you understand what it is that you're charged with in that case, what the state said you did, and when, where, and how they alleged that you did it?
Somewhat. So yes.
Okay, well, when you mean somewhat, in other words, the state's accusing you had broken into these people's home when they were either present or could have been present, and when you broke in, there was an intent to commit a criminal offense. So that's what they're saying you did. And they're saying that occurred on April the 3rd, 2021. So you understand that's what you're accused of having done?
Yes.
Okay. You understand the nature of the charge and the possible penalties for the offense?
Yes, sir.
Right? Now, have you discussed the nature of the offense, the evidence in the case, possible legal issues in the case, the possible defenses you try to raise in trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs presently?
Yes, I take medication from my psychiatrist. It's not mine altering though.
Alright, so it doesn't interfere with your ability to understand what's going on here, to understand what I'm saying or asking you to respond appropriately. You're okay with that?
Yes, sir.
Okay. Now, on page 3, there's a couple of lines that have been printed in bold and underlined, and then part has been stricken out, and then there's been some additional language written in by hand. So let me read it as on that page. It says, defendant shall enter plea of guilty to count 1, state will dismiss count 2, defendant shall pay full restitution, state and defense will argue sentence. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
No one's promised if you plead guilty you're going to get any particular sentence.
No, sir.
Now, do you hold any license or certification from any state agency or commission or any kind of a occupation or profession that requires licensing by the state?
No, sir.
You have certain constitutional rights. You must understand before I can accept the plea of guilty. First of all, you have a right to have counsel, and the court appointed Ms. Witt to represent you. Now, her appointment wasn't simply to work the case out, but to provide whatever defense could be available to you under the law that you would like her to provide. So, if you decide that you don't want to plead guilty, that you want to defend against this charge, she'll continue to represent you and defend against the charge of pleading a trial if that's what you want. Do you understand that?
Yes, sir.
Right, under the Constitution, Ms. Hildebrandt, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial. After they are selected, the evidence will be presented, they'd be instructed on the law, and they will decide by unanimous verdict, meaning all 12 have to agree on whether or not the state proves your guilt by proving beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt or proved beyond a reasonable doubt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily, your request for at least a court order, that's a subpoena, and have force those witnesses to come to court to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to talk about it in the proceedings except in one situation. That is, if there's a jury trial and you don't testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio of every essential element of this offense. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been indicted and accused. In fact, under the law, you're not required to present any evidence in your own defense in trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond reasonable doubt, which is the highest burden of proof that is known in the law. Do you understand that?
Yes, sir.
Right now, you originally entered the plea not guilty, Mr. Hildebrandt, not guilty plea, denied the allegation in the indictment, denied you committed any crime, and that plea exercised all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and admits that you're the one who committed that crime. And that plea waives and gives up all the rights that I've just described for you today, except your right to have an attorney. Because you always have a right to have an attorney, no matter the plea. But with that exception, the plea of guilty waives gives up your right to have a jury or court trial. It waives gives up your right to confront the witnesses against you and to cross-examine them for your attorney. Waives gives up your right to use the power of the court to compel the course witnesses to come to court to testify on your behalf to say it was a state. Waives gives up your privilege against self-incrimination because you're the one saying you're guilty, and that's what she finds you guilty. And waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. Now, it also subjects you to being sentenced immediately by the court, and finally, it waives gives up any right to file an appeal that you think you may have had up until this point in time. Now, if I should sentence you to the maximum sentence under certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
And are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right, now Ms. Hildebrand, do you have any questions about the charge or the possible penalties?
Not that I can think of at this
Okay,
time.
you understand it? Do you have any questions
Yeah,
about it?
I think I've already asked you.
Okay, so you understand it?
Yes, sir.
Okay. Do you have any questions about the plea agreement or any of the conditions in that?
No,
Do you
sir.
understand that?
Yes, sir.
Do you have any questions about the constitutional rights of this claim?
No, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Do you understand that?
Yes, sir.
I didn't say this at the beginning, but since you're not in court with Ms. Witt, if you have any questions or anything you'd like to speak with her about before we go any further, we can do it. I can push you and her into a breakout room where the two of you can talk alone with no one else seeing or hearing you. So do you have anything you need to speak with her about?
No.
Do you have any questions on anything I've explained to you today?
No, sir.
Okay. Then is it your decision to go forward and plead guilty to count one pursuant to the terms of this plea agreement that we've just gone over?
Yes, sir.
Okay, then as to the charge, which alleges that on or about April 3, 2021, in Highland County, Ohio, you did by force, stealth, or deception, knowingly trespass in an occupied structure and separately secure or separately occupied portion of an occupied structure that is a permanent or temporary habitation of Jeff Burnett and Amy St. Clair, when Jeff Burnett or Amy St. Clair or any person other than an accomplice of the offender is present or likely to be present, the purpose to commit in the habitation a criminal offense, the violation of section 2911.12A2 of the Ohio Revised Code, the charge of burglary, a second-degree felony, carrying a possible prison term between 2 and 8 years, set by the judge as a minimum with a maximum of up to half of whatever term is imposed by the judge. In addition to that, as determined by the Department of Corrections, and a fine of $15,000. How do you plead?
Thank you.
Okay. All right, the court finds that on this day in open court, the defendant was advised of all of her constitutional rights, made a knowing and intelligent voluntary waiver of the same pursuant to Criminal Rule 11. These accepted in order to file. The defendant is found guilty of burglary as charged in count 1. Count 2 is dismissed. Court orders a pre-sentence investigation to be conducted, including an assessment for mental health and substance use disorder. The matter will be continued under the same bond, and the sentencing will be October 21st at 1 p.m. That will be in person. Now, see, where are you residing, Miss Hildebrand?
I'm with my kids right now at 11639 Highland Hills Drive.
Okay.
And that's
Well, you need to contact the probation department as soon as we hang up and tell them that you entered a plea of guilty and you need to make an appointment for a pre-sentence interview so they can prepare the pre-sentence investigation report and put all the information that they need to know from you into that report so they're all happy.
Okay.
So as soon as we hang up here, you know the number.
Yes, sir.
All right, you call in as soon as we hang up here then. All right, anything further from council?
No,
Thank you
Your
much.
Honor.